Okay, for the issue of discharge by the breach, you can refer to section number 40 in the Contract Act. The Contract Act under section 40 allow rescission when they are issue of the breach of the contract. Okay, when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promiser may put an end of the performance of the contract unless he has signified or informed earlier by words or by conduct that he would like to continue. So that is to show that in the Contract Act, if one of the party refuse, it allow another party to put the contract into the end. Okay, the party not in breach has the right to rescind the contract in this situation. The first one, in the scenario where there are refusal for the other party to perform, and the other one is disability to perform. Okay, so what are the scenario that lead this? What are the scenario or remedy that can be claimed by the injured party? Number one, repudiate the contract unless they have intention to continue. Okay, but they can claim for damages. Okay, number two, they can continue, and at the same time they can claim for damages. Basically, if you look at even either they would like to continue or either they would like to choose for rescission of the contract, they can claim damages. Why? Because the other party did not carry out what he's supposed to do at the stipulated time as what he's supposed to do. That means it is just like give and take. Okay, if I continue, I should claim for damages. If I cancel because of your fault, I also should have to claim for damages because I am the party who is considered as injured party. What is the meaning of promise in its entirely? The court interpreted the word promise in its entirely means that the right to repudiate the contract can only be exercised if a breach goes to the root of the contract. That means if the breach go to the term and condition of the contract. A breach of an essential part of the contract, or maybe the breach of the fundamental term in the term and condition of the contract. Okay, not by surface of the issue, or not simply breach because of the simple issue. It must be the fundamental issue of the contract. Okay, in this case, Chu Yin Lu versus Visuvalingam, they expressed the view that only a breach of an essential part of the contract would entitle the innocent party to repudiate. Okay. Now, there are also another court case that you can refer to under Muralida versus International Firm. A contract which may be rescinded under Section 40 is voidable, and Section number 65 apply in this particular case. The party or the one of the party put the contract to the end is bound under Section number 65. This is 65, to restore to the party in the default any benefits received from him under the contract. Even if you look at the clause that have been stated earlier under frustration of the contract, if there are any advantage, you can restore, and you have to restore, and you have to return back any advantage that you take from another party. At the same time, the party not in fault, or we can say the injured party, has the right to claim for damages. So if I ask you basically what are the implications, what are the options? Number one, they can choose to continue plus damages. Number two, they can rescind plus claiming their damages. Okay, so this is the long explanation. Rather than, if you refer, you can also see the simplified version in slide number 38. Okay, now let's look at number 4. Section number 76 clearly provide the right to compensation. So you can refer to section number 76, everyone. A person who rightly rescind a contract is entitled to compensation for any damage which he has sustained, which he has suffered through the non-fulfillment of the contract. Maybe because of the non-fulfillment of the contract, the progress of the work is delayed, and then let's say, give you one simple example. Let's say A has a contract with B. Because B did not carry out the obligation, let's say B is a contractor properly, then the delivery of the project for B, from B to A is very long. Let's say A is responsible to pay for the work done by B. B is the contractor. So when B delay the progress of the work, A has to pay the rental of the house because he is waiting for the house to be completed, then only they would like to stay. But now, let's say let's say for this particular issue, A is required to pay to C to rent the house. Okay, so that means A has suffered the damage, or maybe economic loss, or maybe has to deal with another location to rent the house because he may give the notice of the termination to stay in the house earlier. So that are the example of the amount of compensation that they may claim due to the non-performance or a non-proper performance of the contract itself by B, that is the contractor. Okay, so basically before we end the session, to summarize the content, everyone, you have to understand how the contract is called come to the end. That is number one. Number two, we have to know in what scenario the contract can be discharged. Principally, number one is the contract can be discharged by performance. This is the good way where one of the party has fulfilled the requirement. The bad way for by performance is you elect yourself to discharge the contract because the other party did not perform the obligation of the contract, that is by performance. Number two, the good way, because the parties in the contract has agreed that the contract can be discharged. Either they can discharge and form the new one that is known as novation, or it can simply be discharged because of certain issue. Okay, for item number two, you can see that there is no issue of the damages, no issue of the compensation. Number three, we have discussed quite long regarding to frustration. What are the scenario that lead the contract to be frustrated? What are the implications in the law? What can be claimed? How you identify and evaluate whether frustration is happened? Is it valid from the beginning, or is it either valid from the beginning, or it is frustrated at the time the contract is being made? And how, if the event is already stated in the contract earlier, can we say that the contract is frustrated? All of that we have discussed very detailed in item number 3 previously. Last one is by breach, where if one of the party did not fulfill the obligation, another party has the right to claim damages, to rescind the contract, or another option is to continue but claiming for damages. So item number 4, method number 4 is basically showing that by breach, either way, whether you want to continue or you did not want to continue, you still as the injured party allowed to claim for monetary compensation or damages. Okay, so this is the question for this particular tutorial. Okay, look at the scenario here. Batteries bought a HB desktop computer, or we can say that this is actually the computer in February 2020. However, she decided to sell the computer as she wanted to buy another one that is more powerful, the RAM is better, the speed is better. So on 18th of March, Batteries wrote to Charles, I offer to sell you my desktop computer for 2,000. Okay, in this scenario, how will be your advice differ in the following scenario, in the following situation? So you have to get the idea in this case, Who are the offerer? Who are the offeree? Who would like to sell? Who intend to buy? Okay. Now look at the first scenario. Charles accepted Beatrice's offer to buy at 2,000. Can you see that statement? I offer to sell to you my HP desktop for 2,000. So look at the first statement. Charles accepted Beatrice's offer. However, at the time of the contract, the computer had already been destroyed in the fire. Okay, this fact was unknown to both Beatrice and Charles. This is the example in which, let's say, I call. In this case, maybe there are two possibilities. Either you meet in front, face to face, or maybe you call. But at the time the contract is made, both parties did not know that actually the fire burning accidentally, or the fire has burned the content of the contract, that is the computer. Okay, you can see the second statement here. The fact was unknown to both Beatrice and Charles. Explain whether there was a valid contract between the parties. So what you need to do earlier, I give you the idea how to write down whether the contract is valid or not. Okay, at the time the contract is being made, both of them did not know whether the contract content is already been destroyed. Only when, let's say, Beatrice would like to take the desktop to sell, to give to Charles, that only he know, oh, actually there are accident, fire burning at my house. Okay, so you have to give the scenario, you have to explain the scenario to see the status of the contract, whether they are valid contract or whether the contract can put to the end, whether the contract can be frustrated or whether the contract can be discharged or not. All of that will affect the validity of the contract. Okay, so how you want to extract the issue? I give you some of the keyword for you to think about it. What are the issue in the above scenario? Okay, so what are the issue? Basically, the issue is the subject matter had been destroyed. Number two, the issue is the fact was unknown. You remember when we talk about frustration, the fact must be something that is not expected. If the fact is known, then it is not considered as frustrated. The third one, we have to make sure that we understand that it is not possible to carry out with the contract if the subject matter had been destroyed. The first issue that we discussed earlier, destruction of the subject matter. So it almost similar in this case where the laptop or the desktop had been destroyed in the fire. Okay, and there is a question, when you see the word destroyed in a fire, is there any frustration of the contract? So when you see the word yes or no, you have to give the reason why. In what scenario that caused the contract to be frustrated in this particular in this particular situation. Okay, what statement show that the contract can be frustrated? Does clause 57.2 apply? So you have to refer back to the content of section number 52. Is the contract radically different? Radically different at the time the contract is made or after the contract is being made? You have to refer to the previous court case or law case to give the judgment. Look at the doctrine of the frustration and apply in this particular scenario. What is the effect of frustration on the contract? If the contract is frustrated, the implication is void. If the contract is not declared to be frustrated, means the contract has to be continued, both parties has to carry out with the obligation. That is how you identify and answer the validity of the contract for this particular scenario. Okay, so the whole statement here are the question. This is the example of the question. These are the example of the scenario, but there is only one question. Explain whether there was a valid contract. If you only mention yes or no, that means you do not explain. My advice is make sure you discuss first. Last one, the conclusion, then only you mention. In conclusion, there was a valid offer or there was not a valid offer because the issue of blah 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 that had been discussed earlier in paragraph 1, paragraph 2, and so on. So the answer must be only be in the conclusion after you discuss the validity of the contract, discuss whether the contract is valid, discuss the issue, and refer to the Contract Act statute. Okay, so that will be the idea on how you want to answer the question for the a problem solving question. Thank you everyone.